According to the US Constitution, the legislative branch exists to write our laws, and the executive to enforce them. But the process of congressional lawmaking is often slow, deliberate, partisan, even gridlocked. This painstaking process can make for better legislation, but the delay can be frustrating. Little in recent history illustrates this difficult dynamic more perfectly than the case of pharmaceutical company Pfizer, which tried to restructure itself in 2015 and was essentially blocked by the Department of the Treasury before Congress could act. So what was Pfizer trying to do that had Treasury and especially the IRS up in arms? Something called a corporate inversion. Simply defined, an inversion is when a company restructures, moving its tax residence offshore to a different country. Now, usually this is not controversial. Companies may do it for many reasons. But there's one big reason for an inversion that tends to capture the attention of the government, and that's when it seems like a company is doing it as a way to avoid paying taxes. In other words, a tax inversion.
A tax inversion can be carried out in many different ways, and some inversions occur for legitimate business reasons that the Treasury Department would have no desire to prohibit or limit. The difficulty for the U.S. economy by allowing or permitting tax inversions is when the purpose of an inversion is to move taxable income offshore. And it's not to move it to foreign countries that are going to tax at equivalent rates to the United States.
Pfizer wanted to engage in this tax inversion because it felt the taxes it was subject to in the US were too high. The tax inversion it proposed would solve this problem.
The United States had among the highest income tax rates, corporate income tax rates in the world. The rules are different in other countries, and they compete for our capital and our jobs the same way we would like to. And for a long time, our tax system, in particular on the corporate side, had become very non-competitive.
Tax inversions came into their own in the early 1980s when companies frustrated by the high corporate tax rate in the US on worldwide income started moving their headquarters abroad, basically making their companies into foreign corporations. It didn't take long for Congress to notice this and to enact laws to address it. Most notably, Internal Revenue Code Section 7874, popularly known as the 80-60 rule. The law stated that American companies still carried full tax liability if at least 80% of the owners prior to an inversion also remained after, and partial liability if at least 60% of the ownership remained.
Corporations recognized the tax advantages of very simplistic inversions, often called naked inversions, because all the corporation had to do was to create a headquarters in either Bermuda or the Cayman Islands. Congress recognized this as a problem and created a new regime whereby the inversion could be ignored for U.S. tax purposes.
All those foreign companies are now controlled by a foreign company. They're outside the jurisdiction of the United States for taxation. A number of other countries have what's known as a territorial system, and they don't even seek to tax the foreign subs of their companies. So as a planning device, it got out, and it was thought to be competitive. It was a self-help idea.
That's why in 2015, Pfizer announced plans to merge with the Irish company Allergan. The merger would have allowed Pfizer to cut its tax bill by an estimated $1 billion annually. But the news caused a huge amount of public backlash, and Treasury Secretary Jack Lew responded by issuing a temporary regulation outlining how he intended to reinterpret the 80-60 law going forward. The catch? The 80-60 law itself hadn't changed. The Treasury Secretary simply decided that he would change his interpretation of what the 80-60 law meant.
When Pfizer, which was the largest pharmaceutical company in the world, was seeking to invert and was prevented by this irregularly issued regulation, the Treasury turned first to Congress and said, you need to strengthen the inversion law. You need to make it broader and tighter. And Congress responded by saying, no, inversions are a symptom of a greater evil or a greater ill. Our system's not competitive. We need to revise and reform the whole thing.
A lot of people wanted Congress to respond with a new statute. Congress didn't. It took a while for Congress to decide upon an action and did not do anything with respect to tax inversions until 2017. So there was a period of time where a majority of the public was frustrated about the ability of large corporations to move offshore with what appeared to many to be the lack of congressional response. In the light of that, the IRS issued a notice of proposed rulemaking.
Pfizer sued the federal government, claiming it was being targeted since the Treasury Secretary's new interpretation of the law applied specifically to its inversion and not to others underway at the time.
The IRS told the businesses that were considering these transactions that it was going to begin the process of altering the regulations so that many of the original structures would no longer work. So Pfizer's plan would fail the test that was being proposed if they continued with that transaction, which is the largest reason that Pfizer pulled its transaction. Not all corporations at the time did so. So Burger King had proposed its inversion into Tim Hortons in Canada, a company that had also engaged in an inversion from the United States under the earlier regime. That inversion continued because there was sufficient business reasons to validate that inversion even under the new Treasury Department rules.
And then we attacked the substance of the regs as well, saying they were arbitrary and capricious and they were outside Treasury's authority to issue, which was what Jack Lew feared. And we won the procedural arguments. The reg was invalidly issued for failure to follow the Administrative Procedure Act. The upshot, however, was that within a day or two of the reg coming out, the inversion was canceled. So it didn't matter that we won because there was a single target of the regulation, and the target took it between the eyes and was done.
Despite having legal grounds to push back, Pfizer made the call that the legal risks would ultimately be too great, and it canceled the merger, even though there was no new law in place.
The argument often made against the use of notices in this way is that the Treasury Department and the IRS are able to create something that effectively has the rule of law without actually following the proper legal process for creating laws. Congress isn't acting, and the process required under the Administrative Procedure Act is not being followed. So it does, in many ways, look like the government is creating rules without following its own rules in doing so. The difficulty with that interpretation is the amount of time and process required under the Administrative Procedure Act with the notice and comment process means that whenever regulatory or sub-regulatory rules are to be created using a notice and comment, there is a general expectation that it will take between 1 to 3 years. So that when the extremely well-funded industries see an opportunity, they would have ample time to use that opportunity before any loophole is closed. I would say that the notice was effective and was followed relatively closely thereafter by proposed regulations. So it was putting into operation a more effective regime for accomplishing earlier congressional objectives. And it did so in a pragmatic and politically realistic way of accomplishing that goal.
The executive branch enforces the laws and in enforcing them, interprets them. And in interpreting them, they issue regulations. Regulations aren't passed, they're issued. And it's a good process, and it's a useful process. But how do citizens participate in the executive branch interpretation and enforcement of law and the issuance of regulations? Well, we don't vote for the head of the EPA or the commissioners of the SEC, or in this case, the commissioner of the Internal Revenue. So the way that it's thought that citizens participate is through the Administrative Procedure Act, which governs all agencies. But this, we need to get a rule out quick before the citizenry, well advised and with good people representing it, present a persuasive objection or persuasive comment to the contrary. That's a real politic, if you will, that's way too beyond rule of law for me. That goes way to the let's be practical here. This is a good rule. Says who? And now we need to get it out under cover of night because otherwise someone will sue. Well, that's our system. You sue when you think there's a bad reg. And then we listen to the judge because we, as part of rule of law, we believe in the judicial system.
It's ultimately the role of Congress to pass laws. And in this case, Congress did end up passing a law that ultimately codified Treasury's temporary rule. But some still argue that this is an instance where the executive branch exceeded the bounds of its power. So when the next time-sensitive question faces a gridlocked Congress, who do you want to answer it?